kids are different. And I don't want to offend anyone, but they get to a good age of 30. And because they're immature, they're impulsive, they have low educational levels, and if you gave them extra protection, it would at least somewhat ameliorate the differences, the competency differences between adults and children. That's how I read it. On the other hand, you could read it as the usual administrative hearing, fundamental fairness, due process, where's the Sixth Amendment? So many kids were going to get less constitutional protection than adults. At first, Gault followed a broad reading, the court followed a broad reading of Gault. And in the Winship case, it applied the reasonable doubt standard of proof, which is not in the Bill of Rights. It's required as a matter of due process. The court, for the first time, constitutionally applied the reasonable doubt standard of proof first to adult trials. It had never been a matter of constitutional right before. It's just that's what everybody did in criminal court. And then Justice Brennan said, well, now that adults have it, why shouldn't kids have it? And then they applied the reasonable doubt standard of proof. Now, the major setback to my view was McKeever, holding that due process did not require a jury trial in juvenile adjudicatory hearings. We have them here in Texas as a matter of noblesse oblige, not because it is constitutionally required. And the question was not, does the Sixth Amendment right to a jury trial apply in juvenile adjudicatory hearings? The question was whether jury trials were required as a matter of due process, fundamental fairness. And Justice Blackmun, who wrote the plurality opinion, stressed the fundamental fairness aspect of the Gault decision. And he said the earlier delinquency cases emphasized accuracy in fact-finding, and jury trials don't fit into that category because bench trials were not inherently unfair or inaccurate. And if we have jury trials, that would make the hearings too formal and adversarial, and wouldn't enhance the unique benefits of the juvenile court system. To me, the lack of a jury trial in juvenile delinquency proceedings is a discrimination against children because of their age. The famed Calvin and Zeisel jury studies are very interesting, and they were done in the 60s and they have been replicated in more recent times, indicate there is a 25% disparity between bench and jury trials, which means the judges convicted significantly more often than did juries. And this wasn't just a case of jury nullification. The judges were simply more blasé. They had seen it all and heard it all before. Let's get them on. They had the same delinquents coming on. And they had access to information in the probation files, which they got for the detention hearings. And then they sat and contained the kid's statement to the probation department, and then sat as a fact finder in the case. Juries, unencumbered by experience in probation files, show greater lenity. And they give our criminal justice system more flexibility and permit a more humane imposition and distribution of punishment. And juries in juvenile court would allow the child to be judged as an individual rather than as just another member of a class who appeared all the time in court. What's interesting is that the original concept of the juvenile court system was to provide individualized treatment of children. Each kid has different needs. And jury trials are a way of accomplishing that. Because they're unencumbered by the files, unencumbered by prior experience, and they acquit. But their greatest virtue, I tell you, may be the very formality that was complained about in the McKeever case. Because jury trials, more than anything else, tell children the state means business. It tells judges, by the way, that they sit in a court, which they sometimes forget. A real court, one bound by constitutional fetters, and there are consequences for failure to adhere to them, such as appellate review. And if we insist that children who do the crime, do the time, that's one of the things that's popped up, it's only fair that there be no incarceration without jury adjudication. I made that up. No one says that. Now, 3 years after McKeever got my brain out of time, I have little signs. Okay. In the Breed case, see, so it's here. Here's Gault. And here is Winship. Here is McKeever. And now comes Breed, way over here. It's a unanimous opinion. Reading Gault expansively and explicitly finding that the Fifth Amendment double jeopardy clause applied in juvenile court, and claiming it was simply too late in the day to conclude that a juvenile is not put in jeopardy at a proceeding whose object is to determine whether he has committed acts that violate a criminal law and whose potential consequences include both the stigma inherent in such a determination and the deprivation of liberty for many years. Remember, Gerald Gault was sentenced to what functionally was a 6-year sentence for an offense that was punishable by only 2 months or a fine in criminal court. In the Breed case, the court found that the double jeopardy clause prohibited the state from starting a delinquency adjudicatory hearing in juvenile court, aborting it. The judge said, "Oh, this is a terrible crime. You shouldn't be tried in juvenile court. You should be over there." So it stops the adjudicatory hearing, holds away the hearing, and sends the kid over to be tried for the exact same offense in criminal court. And the court said that that was not helpful because it put the kid in the position of, well, I don't know. Am I going to be waved over or am I going to stay here? Should I cooperate with the probation officer or keep my mouth shut? Because when they wave me over, the DA is going to know everything that's in my defense. However, in the Swisher case, goes back a little, the court permitted the state to appeal unfavorable decisions of juvenile court referees, that is, that the child was not guilty. The state had the option of appealing that, quotes, to the real juvenile court judges, and the court said this did not constitute a violation of the double jeopardy clause. Now, one might think that if the court gave children in juvenile court the same rights as adults in criminal court, the inequities would disappear. Justice Black